matter of Lewis-Ranwell against G4S Healthcare Limited and others.
This appeal is concerned with the illegality defence. In particular, it is concerned with whether the doctrine of illegality operates to bar a civil claim in negligence in circumstances where the claimant was charged with murder and found not guilty by reason of insanity. Mr. Alexander Lewis-Ranwell, the claimant in the civil proceedings and the respondent in this appeal, is diagnosed with schizophrenia. On the 8th of February 2019, he was arrested for suspected burglary at a farm in Barnstaple. He was detained at Barnstaple Police Station before he was released on bail at around 2:30 on the morning of the 9th of February. Later that day, he was arrested for having caused grievous bodily harm with a saw to an elderly man, Mr. John Ellis. He was released on bail at around 10 a.m. on the 10th of February. Later on the 10th of February, during a serious psychotic episode, the claimant killed 3 elderly men who were previously unknown to him. The men he killed were Mr. Anthony Payne and brothers Mr. Richard Carter and Mr. Roger Carter. At his criminal trial, the claimant was found not guilty of murder by reason of insanity. This means it was accepted that he carried out the killings, but was found not to be criminally responsible. In law, this verdict is available if, due to mental disorder, the individual either did not know the nature and quality of his acts or did not know that what he was doing was wrong. The claimant in the present case knew that he was attacking the 3 victims, but believed that he was justified in doing so in the delusional belief that they were paedophiles. The court ordered a hospital order and a restriction order under sections 37 and 41 of the Mental Health Act 1983, and the claimant was detained at Broadmoor Hospital, where he remains. During each detention in police custody following his first and second arrests, the claimant behaved violently and erratically and was apparently mentally very unwell. He was seen or spoken to by mental health professionals employed by G4S Health Services UK Limited and Devon Partnership NHS Trust. G4S, the first defendant and first appellant, is a private company to which the Chief Constable of Devon and Cornwall Police, the second defendant, outsourced the provision of forensic medical services. The NHS Trust, the third defendant and second appellant, was responsible for the liaison and diversion services in Devon. L&D services are established to ensure that people with mental health and/or learning disabilities in the criminal justice system are assessed and their risks and needs are identified to inform decisions about where they should receive treatment. During the second detention, a face-to-face assessment by the mental health nurse employed by the NHS Trust was discussed, but did not take place. Devon County Council, the fourth defendant and third appellant, was responsible for the emergency duty team, a community mental health team which includes approved mental health professionals who provided and coordinated assessments in the relevant area under the Mental Health Act 1983. The need for such assessment was discussed with an approved mental health professional employed by the Devon County Council, but was not arranged. The claimant now seeks to recover compensation from the 4 defendants for the consequences of those unlawful killings, including in respect of his detention as ordered by the criminal court, and to be indemnified in respect of his civil liability to his victims. The claimant, in his particulars of claim, alleged that all 4 defendants had been negligent in failing to provide him with adequate care and mental health assessment. His case on causation is that, but for the alleged negligence, he would not have been released into the community in a psychotic state on the 9th and 10th of February 2019. The defendants, with the exception of the Chief Constable of Devon and Cornwall Police, applied to strike out the claim on the ground that it is barred by the doctrine of illegality. The High Court, in a judgment handed down on the 20th of May 2022, dismissed the defendants' applications. The 3 defendants appealed to the Court of Appeal, which on the 20th of February 2024 dismissed the appeals by a majority. The 3 defendants appeal that decision to to the Supreme Court. The Supreme Court unanimously allows the appeal. Lord Hodge and Lord Lloyd-Jones give the judgment with which Lord Reed, Lady Rose and Lady Simler agree. The defence of illegality prevents a claimant from recovering damages if their claim arises from illegal conduct. There are two issues on this appeal. First, in circumstances where the claimant was found not guilty of murder by reason of insanity, is the defence of illegality engaged by his civil claim in negligence? Secondly, if the actions of the claimant cross this threshold, does the illegality defence bar the claimant's claim? A threshold is needed because it would be unjust if trivial acts of unlawfulness barred otherwise valid legal claims. The actions of the claimant do not have to carry criminal responsibility to cross the threshold. Rather, the acts must engage the interests of the state or the public interest. The underlying rationale of the defence is to maintain the coherence of the law and the integrity of the legal system. In novel circumstances, such as this, it is necessary to proceed cautiously on a step-by-step basis, seeking to apply principles established in earlier cases and, where appropriate, develop them incrementally. There is no direct authority in this jurisdiction on the precise question before the court. The previous analogous cases in the United Kingdom involved criminal convictions where the defence of diminished responsibility applied. This is a partial defence which reduces a conviction of murder to manslaughter. By contrast, the claimant in this case was found not guilty by reason of insanity, which is a full defence resulting in an acquittal. However, the fact that the claimant was not convicted of a criminal offence should not be a decisive consideration. There is no justification for allowing the distinction between diminished responsibility and insanity in criminal law to determine the availability of a defence in civil law. First, the insanity defence in criminal law is criticised as being out of date. Secondly, the criminal law sets out clear dividing lines between those who are criminally responsible for their acts and those who are not, because they do not know that what they are doing is morally or legally wrong. The difference is between positions on a spectrum of the severity of mental illness. It has no bearing on the coherence of the law or the integrity of the legal system, which is the crucial consideration. In this case, there is no finding of criminal responsibility because of the claimant's mental illness. The jury's verdict, however, established that the claimant killed the three men. Killing a human being without lawful justification breaches the most fundamental moral rule in our society: you shall not kill. This is true even if the individual bears no criminal responsibility for his actions. The hospital order and restriction order were not the imposition of a criminal penalty. However, it was an order of detention which the court was required to make in order to protect the public as a result of the claimant's actions and his continuing mental state. The claimant's actions manifested the danger he posed to the public and engaged the interests of the state or the public interest. We therefore conclude that the claimant's killing of the three men is unlawful conduct for the purpose of engaging the illegality defence. The second issue on this appeal is whether the defence should apply to the present case based on the trio of necessary considerations indicated by Lord Toulson in Patel and Mirza. These are, first, the underlying purpose of the prohibition which has been transgressed; secondly, and conversely, any relevant public policies which may be rendered ineffective or less effective by denial of the claim; and thirdly, proportionality. The prohibition breached by the killing of the three men is the most fundamental rule that you shall not kill. An important purpose of the prohibition transgressed is to deter unlawful killing, to protect the public and preserve life. This prohibition applies with equal force to an individual who, having killed, is found not guilty of murder by reason of insanity. To allow the present civil claim to proceed would give rise to a series of inconsistencies which would damage the coherence of the law. The judge was required by the jury's verdict to make a hospital order and restriction order to protect the public. To allow the claimant to recover compensation for his detention would be wholly inconsistent with the rule requiring his detention. It would also be inconsistent for a civil court to order the payment of compensation to the claimant for the consequences of his lawful detention ordered by a criminal court. Furthermore, insanity is not a defence to the claimant's liability in tort. To hold that the illegality defence does not prevent the claimant from suing the defendants would be inconsistent with the claimant's liability in tort. In addition, it appears that if the estates of the victims unlawfully killed by the claimant or dependents of the victims were to claim against the defendants, their claims would be unlikely to succeed because the defendants did not owe the victims a duty of care. These considerations relating to the coherence of the law are necessarily closely bound up with public confidence in the integrity of the legal system. Consistency and public confidence are weighty considerations supportive of the view that the underlying purpose of the prohibition transgressed would be enhanced by denial of the claim. We've come to the clear view that the policy considerations in favour of denying a civil claim greatly outweigh those in favour of permitting a claim. We accept that it is, in general, in the public interest that courts should adjudicate civil wrongs. We also accept that permitting civil claims would have the effect of opening up for examination the standards of care provided and what may have gone wrong in individual cases. This may have the effect of encouraging providers to provide better care for the mentally ill and to enhance standards. However, there exist alternative procedures such as inquests and public inquiries which are better suited for these purposes. This conclusion is reinforced by the proportionality of denying a civil claim in the particular circumstances of this case. The acts in question, killing 3 men, are of the utmost seriousness. Those acts are central to all heads of loss claimed in the civil proceedings. In all the circumstances, denial of the claim would not be a disproportionate response to the illegality. For these reasons, the appeal is allowed. The court is now adjourned.